what we've seen previously, I think by large, is people equating disagreeing with somebody's principles about, being an anti-lockdown person, the court disagreeing with that, and then deciding, well, because I disagree with your principles, you must be, guilty, or you must be at fault here, right? And that's not the same thing. We can disagree about principles and still apply the correct legal analysis. This morning, I think the correct legal analysis was applied. I hope that shows a changing of tide and, a reduction of emotional-driven responses to COVID-19 and a return to good legal analysis. But this is just one decision. So I think that Judge Dinkel made the right decision this morning. I hope that continues on a go-forward basis with the courts.
Adam Sos here for Rebel News, and we are here with certainly a little bit of good news. A little bit earlier in the day, we did get some breaking news about sort of a landmark case on some of the COVID-19 restrictions and mandates tickets relating to protests. We were trying to get those court details and try and verify those facts to see if it was indeed as important and as much of a landmark decision as they suggested. Sarah Miller of JSS Barristers, not working on this case particularly, but certainly working on a number of related cases. You were actually listening into court. And can you first off, we can get into the sort of broader implications of this, but can you first talk about the sort of narrower scope of the case specifically?
Yeah, absolutely. So I was attending court as an observer today, not as counsel of record for the defendant, but essentially the issue before the court today was regarding a Public Health Act ticket, where the accused had been charged with attending a gathering in excess of the gathering restrictions back in December of 2020. So the CMOH order said private social gatherings were limited to 0. And so the question before the judge this morning was, what does private social gathering mean? And does that include a public protest? So in this particular instance, it meant the Freedom March. That was what was before the court. Frankly, that's because that's all that's been ticketed in COVID. No other public protests that I know of have been ticketed. I've been trying to monitor as many as I can. Whenever these come up, I try and attend court and keep abreast of them. I'm not aware of anybody else who's been ticketed under Public Health Act for attending public protests besides people of the Freedom March or related anti-mask, anti-COVID type protesting. So the question before the judge today was a public protest a private social gathering? And the judge said, no, it's not. So there was a not guilty finding. And the accused was not convicted under the Public Health Act, and is a really great win because the Public Health Act allows for prosecution up to $100,000 fine for attending in gatherings or breaching a public health order like the CMOH order.
So obviously in this one instance, we have one individual who attended a protest. It's been determined that they were allowed to attend protests, that the protest ultimately doesn't have scope over protests. You also touched on the fact there that it seemed to only be certain freedom-oriented protests that were being targeted. But what is the sort of broader implication? Is this precedent setting? Does this mean that all tickets that were issued aren't subject to the CMOH order?
No, it doesn't capture all tickets. It's not going to be everybody who got ticketed under the Public Health Act or for that particular CMOH order. What you'll have to remember is each CMOH order has different language. In March of 2020, the CMOH orders had very particular language that said very particular things. It was really vague, really broad, really unclear about what was intended, right? But it was issued really quickly. March 2020, suddenly we're under some measure of a lockdown order, right? By December 2020, the language had evolved. But as, we'll all really keenly remember, every few weeks, every, 6 weeks or so, we're getting a new CMOH order, new language, new lockdown measures of one measure or another. So this particular decision really only impacts people who are ticketed, under that CMOH order. So we got to remember that first, right? And so I believe the CMOH order was issued December 11th or 13th or something, 2020. I believe by sometime in January, that one had been replaced by a new one. So we're really only talking about that one, maybe the following one if it has the same language. The other thing you have to remember is some people actually were ticketed for private social gatherings, right? Something that is really at its core fits that description. So I'm not going to suggest what that might be or what it might not be, but some people are going to be ticketed for having something that really looks like a private social gathering.
Right.
What it does mean, though, and it's certainly, at least influential in decisions coming after it or cases coming after it, is that a public protest is likely not a private social gathering. It shouldn't be. That's what Judge Stinkle found this morning, is that it's not. That's what I've been arguing for the past over a year, that it's not. A private social gathering is not public protest. A public protest is a political thing. It's charter protected. We didn't have any charter arguments today. This was just finding the language of that order being either ambiguous or clearly not capturing public protest. So then is there specific language within? I know you were just observing, so you don't have everything written in front of you, but was there specific language in that document that didn't go into documents before? And then I suppose, just as a layperson, it seems to me it'd be pretty easy in court to argue, well, my client is not a lawyer. A week later, you're saying that it didn't apply. A week earlier, it did. It seems incredibly arbitrary. Is there going to likely be, beyond the narrow sort of self-evident protests within that window scope, are there likely to be broader precedent repercussions from that? Yeah, so I think there will be broader precedent repercussions for it. Now, being able to argue, oh, my client's not a lawyer, how would they interpret a CMOH order? That's not a defense. There's really clear case law saying complicated law that's hard to understand, or, creates, a complicated system that's, requires legal advice, doesn't mean that you can plead ignorance, essentially, right? You have to understand that if the law is complicated and you can't read it to understand it, you should get legal advice, right? That's the idea. Or, err on the side of caution, I suppose. But in this case, it's more so that, okay, well, it's really, I think, impactful that the judge a judge has finally been able to opine on this and say, wow, this is, arguably written poorly. We have all sorts of academic papers on all across the country about how poorly these orders have been written, how impossible they are to understand what's actually being captured. In this particular case, we have a phrase, private social gathering, that has been used, not only on that order that ran from, mid-December to mid-January of 2020 to 2021, but that phrase has been used in other CMOH orders. So as far as that phrase being used, it's certainly precedential. As far as, going forward, if we have similar language or language that we can draw analogies from, it's also going to be influential. Now, of course, there's a few things that we have to caveat with, right? One is the CMOH is most certainly going to learn from this decision today. At least I hope so. So if we start getting back into lockdowns in the future, they're not going to be using this language. I feel probably pretty confident about that, that we're not going to see the government recirculate this language. So we're going to have new fights in the future if lockdowns get reintroduced. The other issue that we want to think about is whether or not, as I say, some other event might actually fall within that definition. We're talking about public protesting, so that's good. I hope that we see the residual cases that relate to public protesting be withdrawn. There's all sorts of other things that may or may not fall within that language. You
talked about sort of potentials for lockdowns coming up again, and I do want to talk about some of the sort of repercussions and the mood generally within the courts. But first, I do want to talk about one of the cases you are working on. Obviously, we just saw criminal charges against Pastor Tim Stevens dropped. We're now seeing this victory. It seems on many fronts, even the government of Alberta is applying, which is somewhat hypocritical given what they've done, but for intervener status against the Emergencies Act. On the case of Pastor Artur Pawlowski, particularly the case you're probably the most familiar with, does this decision, how does this public protest, how does that apply to church gatherings? Is there a correlation?
Yeah, so there's going to be similar arguments to be made about, I believe Pastor Stevens has outstanding Public Health Act tickets for his church. Artur Pawlowski, depending on how the Crown wants to proceed, may. So there is that there's an analogy there to be drawn, right? Private social gatherings should be private, should be social. Churches, not private. I've never known a church to turn away people. It's also not social, it's religious. We do have other provisions in a lot of the CMOH orders that spoke specifically to worship services. We've seen success across the country. I've had success in Winnipeg and in Saskatchewan for those types of tickets. I would say I've had success in Alberta, although you never know why the Crown is necessarily withdrawing. So I think there's an opportunity here for further success. I'm glad to see the court look at this and look at it seriously and not just be angry about people who are protesting lockdowns or disagreeing with them or being allowed to disagree with them, but also apply the appropriate legal analysis to it.
Well, one of the criticisms is very often that the courts are slow, but does it seem, despite the delays, despite the lack of sort of capacity for politicians to be held accountable on the stand, now finally that we're actually starting to see some results and we're starting to see some responses, does it seem as though that measure and balance in that due course of time, the courts are starting to get it right or make some correct decisions or uphold the law of the land?
This morning, I felt really reassured with the rule of law and doing proper legal analysis. What we've seen previously, I think, by large, is people disagreeing with somebody's principles about, being an anti-lockdown person, the court disagreeing with that, and then deciding, well, because I disagree with your principles, you must be, guilty or you must be at fault here, right? And that's not the same thing. We can disagree about principles and still apply the correct legal analysis. This morning, I think the correct legal analysis was applied. I hope that shows a changing of tide and, a reduction of emotional-driven responses to COVID-19 and a return to good legal analysis. But this is just one decision. So I think that Judge Dinkel made the right decision this morning. I hope that continues on a go-forward basis with the courts.
Well, Sarah Miller, thank you so much for the update. Always great to have Sarah Miller of JSS Barristers join us for an update. We're going to keep following this story and seeing what precedent unfolds, seeing if this is indeed, at least for the time being, an end to the overreach of governments and a beginning for good decisions coming from these courts. I want to thank you all so much for tuning in. For Rebel News, I'm Adam Sos. Well, there is certainly some good news there, and not the only good news that we have had as of late. We saw the injunction here in Calgary dropped after our successful application and appeal through Chad Williamson at Williamson Law. We also saw the charges against Pastor Tim Stevens dropped here in Calgary, and again now this good news from Sarah Miller. But we can't rest on this little bit of good news that we have received. I want to remind you that Pastor Artur Pawlowski, who spent 51 days behind bars recently, is still in for the legal fight of his life. His charges have certainly not been dropped. If you want to make a tax receipt eligible donation to his legal efforts, you can do so by going to saveartur.com.